Good afternoon once again. Welcome everyone, and thank you for joining the Sexual Harassment in the Workplace webinar. This has been organized by the Nairobi Legal Awards Technical Committee, and we welcome you today as we expand on this topic, especially during this time where the pandemic showed a significant increase in sexual harassment and gender-based violence cases. It is a topic that has been silent, especially in the legal field, and we are glad to present this opportunity to just have an open discussion and see what policies should be put in place in firms, the processes that need to be taken to ensure that either survivors are protected and also perpetrators are apprehended. So without further ado, I'd like to welcome our first presenter. This is Ms. Beth Mishoma. She is an advocate of the High Court, a legal drafter, and member of the Chartered Institute of Arbitrators. She's also a council member of the Law Society of Kenya and the chairperson of the Gender Committee. She is the 2021 honoree of the International Bar Association of Outstanding International Woman of the Year Award, Woman Lawyer of the Year Award in honor of Anne-Marie Hutchinson. And Beth is also a member of the Law Society of Kenya, East Africa Law Society of Kenya, International Bar Association, Commonwealth Lawyers Association, Chartered Institute of Legal Executives, and International Association of Legislation. She's also an author, having contributed to various legal journals such as The Advocate, the East Africa Law Society Journal, and more, and has been a speaker, having presented at the Law VIA via the Internet Conference and the inaugural Conference of Parliament Researchers. She also runs her blog, which is the Legal Minds on, I believe she will provide us with those links. Clearly, she is an advocate with accolades within her own right and is a qualified speaker for this session. Welcome, Beth. I believe this is your cue to begin, and I hope you enjoyed the session.
Thank you so much, Leonora. I hope you can hear me.
Yes, you can.
And you can see my shared screen?
Yes.
So good afternoon, everyone. Thank you for joining us today. I'm honored to be with you to share some insights on sexual harassment at the workplace, and also so that we can have a candid discussions on what positions and policies we need to put in place to ensure that this vice is curbed. My presentation basically will anchor on what is the workplace, what constitutes sexual harassment, who is a perpetrator, what are the kind of mitigation factors we need to put in place to ensure that sexual harassment does not thrive in our workplaces and in the legal profession at large. I will also talk about changing the status quo and the way forward for both the individual and the workplace. So what is sexual harassment? How is sexual harassment defined? The International Labour Organization basically defines sexual harassment as sex-based behavior that is unwelcome and offensive to the recipient. The International Bar Association defines sexual harassment as involving unwanted sexual behavior or sexual-related behavior. One thing we must underscore is that any sexual behavior that is unwelcome, unwarranted, and offensive, specifically in the workplaces and in society at large, is termed as sexual harassment. So what are we seeing? What are the trends of sexual harassment so far in society? Of course, sexual harassment has been prevalent through the ages. This is not a vice that we are seeing, during the 21st century. This has been in place and it has continued to be perpetuated throughout the time. The new trends we are seeing is that, of course, there's a proliferation of technology and social media. So most cases are coming up into the limelight. And unfortunately, one would think that due to the proliferation of technology and social media, harassers or perpetrators would be embarrassed to continue with this vice. But this is not so. Actually, global cases are rising. Cases in the legal society or in the legal profession are at their highest. So how can we actually acknowledge that global cases are rising? We see, of course, and I believe most of us saw the Me Too movement, where women were protesting about sexual harassment in the workplace. It started in Hollywood, but it moved around to a large section of women protesting on sexual harassment in the workplace, in transport systems, and basically in society. But the key word we need to underscore here is that the protest was mainly about women, sexual harassment of women. What happens to our male colleagues or the men in our society who are actually harassed? So far, there are very few movements which deal with this particular issue. And I believe this is something that we really need to put forth, the fact that our male colleagues are also being harassed. So what about the legal profession? The legal profession in itself has actually, for the longest time, ensured that the vice of sexual harassment continues to be perpetuated. This commonly occurs at the workplace or at work-related events, and various bar associations have spotlighted the vice. For instance, the International Bar Association came up with a survey that actually surveyed 135 countries, 135 bar associations, basically seeking to realize what is the prevalence of sexual harassment in the legal profession. Also, the Bar Association of England and Wales has also carried out a survey. The Law Society of Kenya has, through the Gender Committee, has actually come up with a sexual harassment and bullying policy. But what we notice is that most bar associations in Africa, and East Africa in particular, do not take this as a serious vice that needs to be curbed. So I believe as the Law Society of Kenya, we really need to take a lead and spotlight this throughout East Africa. So why exactly does this vice thrive in our bar associations? I believe it is because of the hierarchical nature of the legal profession, where we call each other my senior, my junior, and basically with those terms come connotations, ensuring that any vices, any sexual harassment episodes are kept quiet for the fear to offend a senior, or the fact that juniors perhaps are viewed as people in the law society who should not be able to speak out. But this is changing so far. The young lawyers are a bit more outspoken, but we really need to ensure that the hierarchical nature of the law society or the legal profession does not ensure that sexual harassment continues to thrive. So female legal professionals are prevalently sexually harassed than their male colleagues. But at the same time, one thing we need to note as per the survey of the International Bar Association, from the male colleagues who are sexually harassed in government offices, they're actually more than twice as likely to have been sexually harassed than the male average. So for public servants, what does this basically say about us? So what is the workplace in this context? We have our law offices, our law chambers. We have the corporate legal offices. These are for the in-house counsel who work for private entities. We have for the government legal offices. These are for the state councils, the legal counsels who work in county governments and national governments and parastatals. Our workplace also includes our courts. That is where we spend most of the time. And sexual harassment also happens in the courts, be it a judicial officer harassing an advocate or vice versa. Client offices, when we are sent out to do work in a client's office, What exactly happens that is an extension of the workplace. And of course, we have office retreats and social gatherings that mainly feature colleagues at the workplace gathering together. So this constitutes what the workplace are. So what constitutes sexual harassment? And I want us to have a very candid and practical discussion here. We are not going to gloss over what constitutes sexual harassment. During my years of practice, I've noticed not only do citizens not know what acts constitute sexual harassment, but so do advocates too. So here I want us to get into the nitty-gritty. First, if you're an advocate, a client, a judge who is sharing sexually inappropriate photos and or videos to the workplace WhatsApp, to the workplace telegrams, to other advocates WhatsApp platforms, like, we have the advocates forums. I don't want to get into the nitty-gritty, but if you're sharing sexually inappropriate photos and or videos, that constitutes sexual harassment. Secondly, if you're sharing images or videos such as pornography or salacious, and I've noticed that salacious gifts actually are very rampant right now in our communication as members of the Law Society of Kenya. This constitutes sexual harassment. If you are a member asking sexual questions such as inquiries about a person's sexual history, that is the body count of people, or you tell people or ask people, you're single, what do you do about your life? This constitutes sexual harassment. If you're making inappropriate gestures, this is sexual harassment. If you are sending suggestive letters and or emails, and I have to be candid, I've heard the words, pushed around, words like office husband, office wife, and you put this in letters and emails of official capacity, you are committing an act of sexual harassment. There are those of us who like to give unsolicited neck and shoulder massages. We creep up behind a colleague and start massaging them. This constitutes sexual harassment. Let us stop. There are those who like to inappropriately touch or pinch people or rub or pat and invade personal space or brushing up against a target. I want to specifically speak about invading personal space. I think as a human being, you have the space around you that you don't want anybody to come close to. Letters are there to personal space. Let us not keep on invading personal space. This will constitute sexual harassment. Of course, there are those of us who, forcefully hug other people. If a hug is not solicited or welcomed, you are committing an act of sexual harassment. We have inappropriate compliments, and I must mention that there is a fine line between a genuine compliment and becoming a perpetrator of sexual harassment. You can tell your colleague, you look very smart today, but you cannot tell your colleague the way that dress fits or the way that blazer fits makes me think of other things. Those are inappropriate compliments. Let us check ourselves and realize which line can we not cross when offering a compliment. We have unwanted pressure for dates. If you have asked a colleague on a date and they have said no, leave it there. Persistence does not mean that someone will actually agree to your date. In fact, unwanted pressure is sexual harassment. We have sexual comments about person's anatomy or clothes. There are those ones who like to compare male colleagues' shoes to other things. Please stop. That is sexual harassment. We have those ones who like to comment on female advocates or female clerks' anatomy. That is sexual harassment. We have the elevator eyes, looking up and down at a person in a suggestive manner. That is sexual harassment. Do not do that. And when we are working and a discussion turns from a work discussion to a sexual story time kind of adventure, that is sexual harassment. You are making the people around you feel very uncomfortable with the way you are relating with them. This list, of course, is not conclusive, but we add on to it as we go on with the discussion. So who is the perpetrator of sexual harassment? It can be a male or female in the workplace. Of course, we have a harassment occurring when a male harasses a female or when a female colleague harasses a male colleague. But we are living in the 21st century and we must be candid. Harassment also occurs between a male colleague and a male colleague, or a female colleague and a female colleague. And this type of harassment largely goes unreported. This is because it is deemed that it is quite shameful. We must spotlight on this so that moving forward, we can have a complete picture on who a perpetrator is. Of course, harassment may occur between a senior or a junior to the target. That is either in law firms a managing partner or an associate can actually, harass a partner. So at the end of the day, we have the imbalance, the power imbalance that occurs where a senior harasses a junior or a junior harasses a senior. A perpetrator may also include third parties. These are clients, judges, and advocates from other legal offices. Of course, this includes maybe when you're working on a case, perhaps with advocates from other offices, advocates from the AG or advocates from the DPP, it still constitutes workplace harassment, and these people are perpetrators. Lastly, the pupil masters. The pupil masters who continuously harass their pupils. You are a perpetrator. So what can we do? Once you realize that an act that has occurred can constitute to sexual harassment, make yourself seen. You need to make yourself heard, and you need to make yourself speak up. That is, you must report, you must create awareness that a particular person in the workplace is committing acts of sexual harassment. If you keep quiet, it will happen to another person. If you are unable to speak about it, I would urge that the bystanders, the witnesses to such sexual harassment acts, to make a report to either a partner or the Law Society of Kenya. But keeping quiet does not help us stamp out the acts of sexual harassment. It does not help us go forward or catch perpetrators. You must be seen, you must be heard, and you must speak out. So what can we do? This has happened, what can we do? We need to report. Report to the relevant authorities. You can report to senior colleagues. You can report to a partner or a supervisor, depending on whether you're in a government office or a corporate setting. You can report to the HR and ensure that the Public Service Code of Conduct regulations are dealt with, or any other code of conduct regulations as enacted by your law firm or as enacted by your corporate body. You can report, of course, to the LSK Gender Committee at the Gender Reporting Desk. We have an email, genderreporting@lsk.or.ke. For miscreant judicial officers, please report to the JSC. I believe you will get help. Or to the Law Society, we can take it up. So in as much as we have an ideal utopia where most of us will report and the perpetrator will be brought to book, is this what is happening on the ground? I think not. We have noticed as the Law Society, and also through my years of practice, there's chronic underreporting. And we sought out to find out, why are people not reporting sexual harassment cases? And we noted the hierarchical structure of the legal profession ensures that where sexual harassment occurs between a senior and a junior in the workplace, they are fearful about reporting sexual harassment cases because they fear retaliation both socially and professionally. We have noted there has been a bit of blacklisting of advocates who have reported sexual harassment and a bit of cancel culture, and especially cancel culture because we are in such a socially aware community. We are on social media. You find that at the end of the day, because you reported against a particular partner, a particular supervisor, you will find that people will not associate with you and your brand will be tarnished. We have also noticed that there's a lot of victim shaming. Victims are told you were drunk, you were wearing something short, or you asked for it. This ensures that victims are very fearful about reporting sexual harassment. We have noted, especially in law firms, that ideally when a victim of sexual harassment reports a matter or a case of sexual harassment, there's a lack of presumption of credibility. The questions asked during the initial interviews include, are you sure you did not misunderstand what person A or B was doing? Are you sure that you saw what happened correctly in regards to when a witness is reporting sexual harassment? Then we have the bystander effect. This has actually ensured that there is chronic underreporting, because in a society or in a workplace where we are together and 10 of us are actually present when perhaps a junior sexually harasses a senior, we all think that one of the other 10 people will report what happened. But this is not so, because as human beings, we have the tendency to act as to ensure that we go towards survival, self-preservation. So we all need to come to a space where we need to speak out. Let us not wait for the next person to be able to report sexual harassment. Or we lack clear guidelines on reporting at the workplace. Most law firms do not have a sexual harassment reporting guideline. There is a very big gap here, and we require that law firms should ensure that they have these guidelines in place. We have the acceptance of sexual harassment as a culture in the profession or the workplace. A while ago, we were having a conversation about sexual harassment, and I realized that most women in the profession have actually passed through sexual harassment, and they have kind of accepted this as the norm, that it will end. But we are not supposed to accept sexual harassment in any way or form. We are supposed to stamp it out. So we really need to wake up from the malady, of accepting sexual harassment as a way of life in the legal profession or the workplace. This ensures that underreporting goes on. But we have these specific concerns of our male colleagues, of the men around us, who do not want to report because they see it as threatening their masculinity or their macho culture. The fact that if you report sexual harassment against a lady, you will be looked at not knowing what you need to do in life. But this should be stamped out completely. Sexual harassment is sexual harassment, whether against a woman or whether against a man. So how do we change this status quo? How do we change the status quo of chronic underreporting or ensuring that nothing is done about sexual harassment cases? We need to do two things: encourage individual involvement and responsibility, and secondly, mitigate against the factors that cause underreporting. So how do we encourage individual responsibility? The role of the individual comes out in 4 steps. First and foremost, as an individual, call out all forms of sexual harassment. If you are a victim, if you're a bystander, if you're a witness, ensure that when you spot sexual harassment, you speak about it, you raise awareness. This will ensure that the vice can be stamped out. Secondly, ensure that you intervene as a bystander or be a supportive colleague. And what I mean in regards to intervening as a bystander, if you happen to notice sexual harassment in your workplace, by all means, go and report it. It does not need for a victim to report the sexual harassment case. You are a witness, you can do that on behalf of the victim. If you cannot report, be a supportive colleague. ensure that the victim is taken care of in regards to ensuring that their self-esteem is bolstered up, ensuring that they can write their statements properly when they decide to speak about their sexual harassment incident. But do not bring your colleague down. Do not start bringing up their past, their party life. Be a supportive colleague. Step 3, reflect on your own behavior. Perhaps there's some of us in this meeting who have not known that some acts constitute sexual harassment. And today you have known. Reflect on your own behavior. Reflect on your own behavior and ensure that you stop any acts that constitute sexual harassment immediately. As an individual, you can also affect change within your organization. If you notice that your organization does not have a sexual harassment policy, by all means, go ahead, draft one, and ensure that it is adopted in your organization or enacted in your organization. This will ensure that you can be able to stop the cycle of sexual harassment within your organization. As a workplace, what can you do? What is the way forward? We need to re-examine, adopt, and implement any policies on sexual harassment, recognition of sexual harassment cases, and reporting, and also disciplinary measures. As I have mentioned, every government legal office should have a sexual harassment policy. Every law firm should have a sexual harassment policy. As long as you have more than one employee, you should have a sexual harassment policy. Every corporate must have a sexual harassment policy. If these policies were drafted maybe some time back, you need to re-examine them and ensure that they're up to date with the current trends. Partners, supervisors need to enforce a code of behavior or a code of conduct. If the harasser or the workplace is maybe a law firm, and you find that most people in the law firm are lawyers, you have the Law Society of Kenya Code of Conduct for Advocates. Ensure that you enforce it and cascade it within your firm, within your legal department, or within your corporate entity. Partners and supervisors must maintain an open door policy. Be accessible to your associates. Be accessible to your partners. Ensure that they can be able to tell you anything that ails them, including sexual harassment incidents. We need to treat all cases of sexual harassment with the sensitivity that is deserved. There are those victims who are very vocal and courageous, who will want to speak out despite the consequences. But there are those of them who are quite quiet and require confidentiality as they go through the process. So every case is different. Treat it with the sensitivity it deserves. Of course, in our workplaces, we need to take swift and decisive actions as complaints of an incident which has been reported take more than 6 months. It is not rocket science. Let us deal with it swiftly, because in those 6 months, the perpetrator may as well continue harassing other people in the workplace. Partners and supervisors must take ownership for the safety of all within the workplace. This is quite serious. As a partner or as a supervisor, all people that are under your purview are the ones who look up to you for their safety. You must protect them against sexual harassment from clients, from judicial officers, and from all other people that visit your firms or your legal departments. Of course, we must schedule training sessions for new employees and refresher sessions for all staff. This can be done periodically, perhaps sent them to a training of the LSK or the LSK Nairobi branch, the Technical Legal Awards Committee. Ensure that they are taught, or you can bring someone to your office to teach each and every employee on what constitutes sexual harassment and how do you report it. Partners and everyone in the office must create a safe and productive workspace, safe from sexual harassment and bullying, a workplace that people may be able to speak about incidents of sexual harassment and be confident in reporting any such incidents. We must, as lawyers, lighten up on the legalists. Let us realize that as lawyers that not everybody in our workspace is well versed in the legal language. Let us make it as simple as possible. Let us make our codes of conduct as simple as possible, our policies as simple as possible, so that any person, including a layman, may be able to understand what constitutes sexual harassment and how to report it, and what are the consequences if you are found to harass people in the office or in the workspace. We must encourage reports by witnesses. This goes to the supervisors, the HR, the partners. Ensure that when a witness comes to you to report the matter, don't tell them to go bring the victim. Encourage them to report, listen to them, and then begin investigations. A witness report is as good as a victim report. Encourage witnesses to report without any repercussions. Get that judicial officer. I put that there very candidly, knowing the opportunity cost that would happen in the event that either a partner or an associate has been harassed in your firm by a judicial officer, and the retaliation that might occur from the judiciary if this matter is brought forth. But as a partner, as a supervisor, you have a duty of care towards the people who work with you. You must ensure that a judicial officer who is a miscreant will be made accountable for any sexual harassment incidents. The cost might be high to your firm, but I believe that if you have a safe working environment, then any business can come to you. Any judicial officer would be glad to have you appearing before them. But get that judicial officer. We really need to stamp any sexual harassment incidents within the judiciary or cross-setting within the judiciary and the advocates who appear before them. If anything, COVID-19 has taught us is that we can leverage on technology. Technology is quite an ample tool to use, especially when trying to deal with sexual harassment cases. This technology is quite splendid when you're trying to have victims, ensure that victims come to you. And if as a firm, you're trying to ensure that confidentiality reigns supreme, come up with a platform. Come up with a platform to ensure that confidentiality reigns supreme, that people can actually, within their own spheres, within their homes, can report sexual harassment incidents. And this is quite important, especially right now that maybe some of us are working from home. We can ensure that all sexual harassment incidents do not go unnoticed or unpunished. So as a partner, as a supervisor in your legal department, why is mental health and emotional well-being so important in regards to cases of sexual harassment? Statistics show that sexual offenders in sexual harassment often have problems stemming from their own homes or from their own emotional well-being. As a partner, the onus is on you to ensure that you create an environment which ensures that emotional well-being is put as a #1 priority, so as to ensure that people do not carry their baggage from home and come and dump it in the office. Secondly, as a partner, promote gender equality. When you promote gender equality at an office, at a legal department, as a supervisor, then you will realize each of the parties know their rights. They know they are treated equally and that there is no favoritism, whether you're a senior partner or a junior or an associate or a clerk in that particular office or anyone else in a particular legal department. You are at par. It also encourages reporting. It encourages for people to feel very confident in coming to a supervisor or HR to report. As a partner, always promote gender equality. So for myself, I speak against sexual harassment, and I urge anyone who has the same problem to come to us at the gender desk of the Law Society of Kenya. Speak against sexual harassment. We will listen to you. we find the time to come to the Secretariat if need be. You can write us an email so that we can be able to sit with you, advise you, and see how we can move forward in regards to speaking out against sexual harassment. We also are very open to any comments on how we can make the experience of reporting very free and hassle-free to ensure that victims do not feel harassed during the process. We also promote gender equality, and we are asking each and every one of us to do the same. This will ensure that our workplaces are safe. Finally, thank you so much, the technical team, for inviting me. Thank you, Leonora.
Thank you so much, Beth, for this such an informative presentation. It was good to know that witness reports are just as important as victim reports, and silence during such occasions does nothing but encourage the perpetrator to continue with their behavior. There was so much information shared, and I would encourage all participants to ask any questions they may have in the comment section, and we will have a Q&A session at the end to address them. Our next speaker is Mr. Ribin Ondwari. He is a partner and the head of real estate, banking and financial services department at Ashitiva Advocates. And he was named Young Lawyer of the Year at the inaugural NLA Awards in his first year of admission, having been admitted to the bar earlier that year. Such an amazing achievement. And he deals primarily with, as I said before, real estate, banking, and financial services. Welcome, Mr. Ondwari. We look forward to your presentation.
Thank you very much, Leonora, for the introduction. And allow me to also thank the Society Nairobi branch for organizing this very important session, and also Beth Choma for laying that very important context and foundation to this discussion, and for the very good work which you're doing with the Gender Committee and the rest of your team. So thank you very much, everyone who's involved and all that. So pretty much my task has even been made much easier by Beth's presentation, because she's covered the entire framework of the context of the happening of bullying and sexual harassment. She's given those case studies and everything, but the key aspects that I then want to deal with is what are the procedures then for complaint mechanism, internal procedures within our law firm, as Beth very well presented to us. Don't keep quiet, be seen, speak out. But then what are these procedures of speaking out, and how do we go about it internally as people lodging the complaints, and also as the leadership, how do we deal with these aspects within our respective law firms? The Law Society of Kenya presented a very did a very good policy in 2019 that addressed most of these internal procedures. But also in practice, there's also a very good policy which has been set out by the International Labour Organization, which both of them really set out the complaints procedures, which have been highlighted in a very interesting way. And there's no point for us to reinvent the wheel when this has already been done properly. So before I go into the complaints procedure, I'd just like to re-highlight, as Beth has said, our workplaces are some of those places that we spent a significant amount of time. And these places then ought to be safe and secure for all of us, not only just for purposes of us being safe and secure, but also even for our performance, because we cannot expect people to perform their best if they don't feel safe and secure, and if they don't feel like they're able to bring their best selves to their places of work. So beyond that aspect of that as an individual being entitled to that safe and secure place, there's also that additional aspect that as teams, we also need to have a safe and secure place so that people can also bring their best selves to work and then be able to just freely deliver. And more importantly, because of the significant amount of time that we all end up spending at workplaces. So in cases of complaints of sexual harassment, how then are they dealt with? So ordinarily, most organizations usually have complaints resolution procedures, but then there's an increased need for there to be an additional specialized sexual harassment complaint process. This is basically to ensure that the specific nuances are dealt with, and also the victims are also, or rather the complainants are also dealt with the sensitivity and also the sensitivity that such complaints would require. And also these processes should also be set out specifically so that there are enough mechanisms set out for investigation of the complaints, and also ensuring that the complaints are then dealt with properly. So as I said, mostly I'll be relying on the policy by the Law Society of Kenya, and also there's a policy by the International Labour Organization, which have very well set out these policies. And also, as you'd recall, as Beth had also mentioned, is that there's a legal obligation under Section 6 of the Employment Act for all organizations that have employees more than 20 to have the sexual harassment policy, which would include these processes. So pretty much you'd have both formal and informal resolution mechanisms. Again, this one's best practices as they're dictated by the complainant, because in some instances the complainant would want the complaint being dealt with informally, if that is sufficient to ensure the process, the accused person in this place, the complaint has been brought to their attention, it has been discussed, and the activity stops. But then in some instances, the complainant may prefer a formal process, or rather it may not be appropriate for that particular situation to have an informal process. So when someone then feels that they've been aggrieved due to sexual harassment, then they should immediately report to their supervisor. If not their supervisor, some organizations, based on their policies, they would have a designated person for receiving a complaint of sexual harassment. So when the supervisor or the designated person receives the complaint, he or she will then immediately record the date, the times and facts of the incident. And then the person will ascertain the views of the victim as to what outcome he or she prefers. And then the person also has an obligation to ensure that the victim understands the company's procedure for dealing with the complaint. Then after they have to discuss and agree on the next steps, there comes the aspect of either informal or formal complaint. But then also this is also subject to an organization's policy, because then some policies we've seen in organizations do not provide for this informal process, rather only have that formal process. So if your organization provides for either both, then you can have a discussion with them. And again, as I've mentioned, it has to be subject, best practice is that it's subject to the complainant's preference. And then on the understanding that choosing to resolve the matter informally does not preclude the victim from pursuing a formal complaint if he or she is not satisfied with the outcome. And then a key aspect is that the person receiving this complaint, the supervisor or the designated person, has to keep a confidential, all these discussions confidential. Then they must also respect the choice of the complainant and ensure that the complainant knows that they can lodge the complaint outside the company through any relevant country's legal framework. Because again, some of these complaints can escalate to the point where they reach the threshold under the Sexual Offences Act. And again, it's the victim's preference to either lodge either way or one way, and that has to be explained to them. So, throughout the complaint procedure, it's important for the supervisor or the designated person to help the person who's made the complaint in terms of following up through the process. And in instances where the organization has sort of a counselor, or if they don't have their mechanisms of having access to this, because some of these instances can have a heavy mental health aspect towards the individual. So if the victim chooses to deal with the matter informally, the designated person will give an opportunity to the alleged harasser to respond to the complaint, and then they'll ensure that the alleged harasser understands the complaint mechanism. They'll also facilitate a discussion between both parties to achieve an informal resolution. This, again, as I mentioned earlier, it has to be a resolution which is acceptable to the complainant. And if, again, you find sometimes there are policies which then note that if such a resolution is not satisfactory to the complainant, there could be a situation of a designated mediator within the company. But again, you still have to go back to the policy of the company to see to what extent that is applicable. As noted earlier, the record of these processes has to be kept confidential regardless of the outcome, and then ensure that then this is also done speedily within the designated time noted under the policy of the company. So if the victim is not satisfied with this informal process, or they straight away chose to go to the formal complaints mechanism, then the person receiving the complaint will then take the complaint through a formal mechanism process. This involves interviewing the accuser, the alleged harasser, separately, and then interview other relevant third parties separately. Again, as Beth encouraged us, it's important to either independently give witness statements, or if not independently, if someone witnessed this, it's important to then be agreeable to give this information. And then the person carrying out this investigation has to make that formal decision whether it meets that threshold based on the definition of the policy. Important to note here is that Section 6.1 of the Employment Act actually specifically mandates a scope which has to be met within the policy as to what then falls under sexual harassment. So once they've interviewed both the accuser and the harasser separately, any witnesses, they have to produce a report detailing the investigations, the findings, and any recommendations. So if their finding is then that the harassment took place, there has to be a decision which has to be made in respect to the appropriate remedy to the victim, and best practices. This has to be done in consultation with the victim. Again, as noted, subject to the threshold under the Sexual Offences Act being met, most of the remedies at this level of just harassment, you can find either an apology, a change to working arrangements, and disciplinary issues, suspension, dismissal, just within the premises which the organization then would have decided under their policy. And then you find then after that follow-up to ensure the recommendations are implemented, that the behavior has stopped, and that the victim is satisfied with the outcome. As you notice throughout this process, there has to be that key attention to ensure that the process, the victim is actually satisfied with the outcome. So if the party cannot determine that the harassment took place, they may make a recommendation for maybe structures to ensure proper functioning of the workplace. Then there has to be a record of all the actions taken, ensure that all the records concerning the matter are kept confidential again. The process is done within the days set out in the policy, but again, there has to be a reasonable attribute to ensure these matters are dealt with as fast as possible because of their sensitivity and all that. So as mentioned, this is just the internal mechanism processes within law firms. There are other complementary aspects which then follow outside the law firm processes, and those ones will be addressed as we continue the discussion. So, subject to there being any other questions, thank you very
much. Thank you so much, Ruben. That was quite informative. it's enlightening to know that the policies have to actually consider and ensure that the victim is comfortable throughout the process, and that there's a safe space created. There's actually a complaint system in place for one to report, and that investigations are carried out to come to a conclusive finding of such situations. Thank you so much for that presentation, Mr. Ondwari. We really appreciate it. Our next speaker is Mr. Senior Counsel Buta Siganga. He attended the University of Nairobi and was admitted as an advocate of the High Court in 1987. In 2020, he was conferred with the rank and dignity of Senior Counsel. And between 1987 and 2013, he was in private practice in Nairobi and Kisumu. From 2013 to 2018, he served as chairperson of the Advocates Complaints Commission. And from 2019 to date, he has been the partner at Siganga and Njora Advocates, with offices in Nairobi and Kisumu. Mr. Senior Counsel has served on various boards and administrative tribunals, including the Ethics Committee of Western Kenya, the Advocates Disciplinary Committee, and also the Task Force on Legal Sector Reforms. He's currently the chair of the jury of the Nairobi Legal Awards and the board member of the Estate Agents Registration Board. He is a trustee of the New Life Home Trust, a baby rescue center, as well as a member of the Rotary Club of Milimani. He is married to Charity and they have one son known as Chris. It's an honor to have you, Senior Counsel. We welcome you and we thank you for making time for this presentation. Kindly proceed. We look forward to learning from you.
All right, thank you. And good afternoon, everybody. Okay, so this afternoon I'll be talking about sexual harassment and discipline. First, I'd like to thank the LSK Nairobi branch for inviting me to speak today. It's a privilege to be able to do so. And thank you, Beth and Ribbon, for your presentations. You've laid a very good foundation for what I'm going to be talking about this afternoon. So I'll get right into it. Sorry, all right. So, by way of introduction, advocates are subject to discipline for violating rules of professional conduct. So, the rules and regulations of under the rules and regulations of the profession, there are provisions for discipline of advocates, and we'll talk about that in a short while. But when we talk about the legal profession and sexual harassment in the profession, we need to remember that the profession has always been a microcosm of the greater society. So the things that are happening there, the things that are happening in the profession are very probably also happening in the society. And then just yesterday, I was reading a report of a team that went to Kwale prison for a legal aid process. And they say that 90%, 97% of all the people they interviewed were there for sexual offenses, defilement, incest, rape, indecent assault. And so sexual misconduct and harassment are widespread. And the problem has become particularly acute in the last 70 years because that's when a lot of women entered the formal workplace. So that interaction has given rise to more complaints. And now we have, in our own profession in Kenya, we have 19,294 advocates who've signed the roll. And you can see that over the years, the proportion of female lawyers has been increasing. As of yesterday, it was 55.2%, while the male were 53.3%. Now, of course, if you add those two percentages, you'll come up with something like 98.5%. The Law Society has I think 275 advocates who are classified as unknown. And I suspect I might have contributed to their indecision on this because perhaps those particular members have first names that are ambiguous, like Buta, so they don't know whether to classify them. So they just put them in the unknown category. But getting down to the legal profession, studies have shown, and I think Beth mentioned this earlier, that 91% of perpetrators are male, while only 5-6% are female. The statistics also compiled about the legal profession show that most harassment takes place in group settings. And let's see if we can get the sorry. Need to back up a bit. Okay, so there we are. Yeah. So 37% of reported incidents took place in group settings, so either at the office or a business meeting, 23% in private, 22% at social events, 6% during business travel, and 9% during online or digitally. So I'll talk a bit about misconduct when it comes to sexual harassment. And there's a definition there. We've already received the definition, so I'll just move on. But if you go to Article 27(3) of the Constitution of Kenya, we read that men and women have the right to equal treatment, including the right to equal opportunities in political, economic, cultural, and social spheres. So the Constitution is very clear about the equality of everybody. If you go to the Advocates Act, in defining professional misconduct, it states that it includes disgraceful or dishonorable conduct incompatible with the status of an advocate. Again, that's very clear. Now, if we go to the Code of Standards of Professional Practice and Ethical Conduct, SOPEC, number 12, this is what it says. An advocate shall at all times maintain the highest standard of honesty and integrity towards clients, the court, colleagues, all with whom the advocate has professional dealings, and the general public. And then it goes on to give an explanation. And I could just, sorry. Paragraph 152, that is. Okay. It states the rationale for the standard is that honesty and integrity are the hallmarks of a member of the legal profession. By adhering to the highest standards of honesty and integrity, a member of the profession will promote trust in the profession Dishonorable conduct on the part of the advocate, either in private or professional life, will reflect adversely upon the advocate, the integrity of the legal profession, and the administration of justice. In paragraph 154, then now it goes to deal with the issue of sexual harassment, and it says conduct in the private sphere which might attract disciplinary action includes conviction for a criminal offense involving moral turpitude. Sexual harassment falls into this category, as do fraud, abuse of a position of trust, and similar offenses. Such conduct, even if not in the cause of the practice of law, amount to professional misconduct. So we see from SOPEC 12 that before sexual harassment as a disciplinary offense, before it can be established, there needs to be a criminal conviction. Because they talk about moral turpitude, it looks like domestic violence, rape would also amount to misconduct, but then again, only after conviction. And so some of the other cases that have been discussed today, quid pro quo, nipe nikupe, hostile environment created in an office, because they don't result in complaints to the police and therefore convictions, it seems they're excluded from that misconduct. And because it just says criminal offense and gives examples, it doesn't make clear whether an advocate's fitness to practice law is implicated by every crime or just whether those ones where they say moral turpitude is involved. Section 23 of the Sexual Offences Act also creates the offense of sexual harassment, and it refers to somebody in authority or somebody holding a public office from making unwelcome sexual advances. It sets out the evidence required. If you have to prove that offense, you have to show that there is a connection between an advance or request and the career of the victim or a service due to a member of the public. Additionally, that the request creates an offensive learning or working environment. So if it's working, if you're in school, if you're in a working environment, that's easy. But for some of the things that we've talked about, things that happen between lawyers in different law firms, lawyers in court, and so on and so forth, those would be excluded. I think Beth talked about impediments to reporting. I think I'll skip that just for sure, but maybe I should say this. I checked with the disciplinary committee, the secretariat. I asked, how many cases of sexual harassment do you have filed in the recent past or ever? And they could only come up with one, decided in July this year. It was a client against a male advocate, and it wasn't a standalone sexual harassment case. It was many other things were alleged in that particular complaint. The advocate was actually found not guilty of sexual harassment. It's an interesting judgment. I think you can ask for it from the secretariat and have a look at that. I'm also informed that another has been lodged recently. It hasn't escalated to a complaint before the DC, disciplinary committee. But then you can see not very many complaints are being filed. And when you look at reporting, you find that, and the American Bar Association did a survey of business and law firms and found that 68% of the respondents indicated they had been harassed, but only 30% had reported it. So there's very low reporting. Okay, so what are the impediments to reporting? I think Beth had said those, so I think I'll skip those. Why aren't this being enforced? You'd expect the law society and the police and all would be very interested in enforcing the law regarding sexual harassment. But I think one of the issues that keeps coming up is, and this I found in other jurisdictions, is that the rules are not clear. Is sexual assault, is sexual harassment sufficiently related to the practice of law to justify professional discipline? Because many times it's argued that these are private issues between adults, and so if they disagree, then they should deal with them rather than making them disciplinary issues. Again, as I said, women in the workforce really only in large numbers over the last 70 years. The Advocates Act passed in 1949. So those were not issues that were complained about then. And it took us up until 2017 when SOPEC came to finally mention sexual harassment in the rules regarding discipline. Again, in the US, every state in the US has different rules, but some have found that domestic violence and harassment don't bear on a lawyer's fitness to practice law, and that it's not clearly prejudicial to the administration of justice. So there's also ambivalence among bodies that are supposed to be enforcing the rules about what exactly it is. So again, there's an ongoing debate. Does domestic violence beyond workplace sexual harassment, should it rise to the level of professional misconduct? Okay, so why isn't sexual harassment or complaints of sexual harassment being enforced? One is non-reporting. They're just not being reported. Secondly, harassment is sensitive, very sensitive personal issue. Many times the victims wait for a long time before coming forward for the reasons that reporting can have repercussions on their careers, on their lives, and things like that. And when they finally come up, their motives are questioned. You might find that evidence might be lost. Their credibility will be on the line. Again, there are those who develop post-traumatic stress disorder and basically just fall apart because of what has happened to them. And so sexual harassment is a sensitive subject. Really, sexual offenses are grossly underreported, and very few advocates, as we've seen, actually make complaints. Let's talk a bit about just the ethics of it. To what extent, and we probably don't have time today to actually debate this, but these are questions we need to think about. To what extent should advocates be held accountable for their sexual conduct? Where do we draw the line between conduct that is purely private and no one else's business, and conduct that warrants disciplinary proceedings and legal sanctions? And how do we decide how to draw this line? What are the factors we'll consider, and what are the principles that operate on this? And I've just suggested some, whether the conduct, is it illegal and criminal? That seems to be the standard of SOPEC. Is that the standard we want to adopt? Relationships involved, is it advocate, client, lecturer, student? Clients have also been known to sexually harass advocates. Third parties, I read of a case where a lawyer whose client was in custody had an affair with his client's wife, and that became a disciplinary matter in the US. Again, the status of an offender, should a senior judge be treated, or should he have a higher standard than a newly admitted advocate, or is it the same? Do we need to consider the social distance between the offender and the victim? What's the status of the victim? Is that something we need to consider, whether the person is young or handicapped? In an American case, a lawyer defiled his 10-year-old stepdaughter. Subsequently, he divorced his wife. Subsequent to that, and with his former wife's consent, he married his stepdaughter. And when that was discovered, then he was disciplined for that. So, those are some of the things we consider. Locus of the offense, do we consider whether it was an advocate's office, a restaurant, an apartment? The harm done and the strength of the available evidence. Those are some of the things that we need to think through as we think about what we need to do. So I'm going to make some proposals and then finish on basically what we need to do about this. And the first I say is that we need to develop a coherent philosophy of lawyer discipline to deal with sexual misconduct that addresses the parameters of professional relations and the nature of the conduct. Secondly, we need to clarify the rules. Requiring a criminal conviction before disciplinary action taken seems to be a very high standard, because while it covers domestic violence and bullying, it seems to exclude a lot of other things. And it doesn't seem right that an advocate who is charged but not convicted of a serious offense can continue practicing law without sanction, because the standards of proof in a criminal case and a disciplinary are different. Why can't we go directly? So long as we address concerns regarding due process, it should be something that we can do. The rule should consider the quid pro quo and hostile environment within the ambit of lack of integrity. I think I've said something on that. Anonymous reporting, because currently you have to come and say, I'm ACD and this is my report, that deters people from reporting. And while it may be necessary that they disclose who they are so that the victim can know who is accusing him, how can we do it so that there's even more confidentiality in the matter? Again, retaliation. What are the things that will be done to ensure that there is no retaliation? And one of the things that the Advocates Act needs to do, and not just for sexual harassment, but for all offenses, is to provide immunity to individuals who file complaints against advocates. A couple of years ago, when I was at the Complaints Commission, I was in Kangundo, and I was talking to the deputy county commissioner, and he's telling me about somebody who had come to see him. He made a complaint that was dismissed, and the advocate successfully sued him for defamation and obtained judgment for $500,000 shillings. And so he had put him into civil jail so that he could get payment. So we need to ensure that things like that can't happen to people who bring complaints if they're done in good faith. Disciplinary proceedings are not criminal proceedings. As I've said, the standard of proof in disciplinary is clear and convincing evidence, and that an advocate engaged in misconduct. So it should be possible to find misconduct in the absence of a prosecution or a conviction, and even if the advocate is acquitted or pardoned for his conduct. Whistleblowing, which we saw the statistics earlier that about 37% of incidents of sexual harassment are done in the presence of witness. It's the largest proportion. So those who see ought to be able to go forward and make the reports, and there needs to be some protection for them so that they are not victimized for reporting a colleague's sexual harassment. Many law firms, I think following the LSK policy, many law firms have a written policy banning sexual harassment. But as Reuben said, we need specific sexual harassment policies also to be passed. And then again, apart from the policies, we need training, either regular or compulsory training, so that a message is sent to everybody in a law firm that sexual misconduct is not tolerated. The disciplinary committee needs to receive and deal with complaints of sexual harassment so that they set out the principles necessary. And that's why I'm recommending that this judgment, have a look at it, because it states some important things that we need to keep in mind, but it shows that that particular area of law, the rules are not yet settled. But if the DC is sanctioning them, people might be encouraged to come forward. And the profession must adopt a zero tolerance approach to sexual harassment. There needs safety in the workplace, and we need to do all we can to combat sexual harassment. All complaints should be taken seriously, and complaints should be investigated. Now, in the US, some states have come up with something they call that the harassment has to be severe or pervasive. Again, that's a deterrent, because if you're harassed once, then they're saying you can't come forward. You have to wait for a second or a third time before you can have a case. And those are some of the things we need to think through and say, what are we going to do in Kenya for the benefit of our environment? And then, just as a follow-up to the earlier point I'd make, because the law allows it, advocates should consider lodging complaints that they witness, even if they're not the victims, because for the Advocates Complaints Commission, under Section 53(4) of the Advocates Act, any person can make a complaint regarding the conduct of any advocate. For the disciplinary committee, Section 60, subsection 1, any person can make a complaint. So long as you have the evidence, then you can report. It's not just the victim. And I think those are protections that I put so that if the victim is either unwilling or scared of doing so, then that can help. I'll stop there and just thank you for listening. Thank you.
Thank you so much, Senior. That was a very comprehensive presentation. It was quite clear that we need to develop structures or other policies that allow anonymous reporting in our firms, in our departments, just to be able to protect the victims and prevent this recurrent form of shame when it comes to being a victim of sexual harassment. Another thing would be even providing immunity, as you said, when you sat in the disciplinary committee. It was quite something that pricked my brain when you mentioned that it would be something that maybe the Law Society can think of and can try develop, just to protect the individuals who report these cases from such backlash once reporting the advocates. So I believe we have finished our presentations. However, there are a few questions in the chat section. And as we all know, as much as the harassment policies and the departments, the HR departments are put in place to be able to reduce such cases. Not all firms and companies have this in place. So Wendy is asking, what recourse is there for victims of sexual harassment in a firm with small number of employees, no sexual harassment policy, no HR department, and the harasser is perhaps maybe the managing partner of the firm, noting that such situations make victims fear to file complaints for the fear of negative repercussions on their careers. I'll let maybe Ms. Michama to address this.
It's quite unfortunate in this particular scenario, but the gender committee, we receive quite a lot of these cases where victims come up, where they tell us their issues with a partner of the firm. And the same scenario, there's no sexual harassment policy. It is not mandated by law, but it is a moral issue in such a small firm. So ideally, we ask all firms, whether it's 2 employees, to ensure that a sexual harassment policy is in place. But in the event that this incident has occurred, so what is the recourse for this particular employee? Please come to the Law Society of Kenya. We always try to ensure that we deal with these matters confidentially as possible. We might be able to give you a solution. If you can come forward and basically ensure that you file a complaint against your perpetrator, we'll take it in due course and with due speed to solve it for you. Because as you can see in this particular issue, there's no superior you're going to be able to ensure that deals with this particular issue. But at LSK, at the gender committee, we'll take it up for you. And I know the fear of retaliation is basically one of the things that ensures that victims do not report. And it is quite across. I've had very heartbreaking interviews with advocates, both in law firms and actually government legal offices who cry about retaliation, and at the end of the day, they are unable to file a report which you can follow through. But what we encourage victims in this particular scenario, come to the Law Society of Kenya. We have a form, we'll fill it for you, we'll sit with you during the interview, we will give you the courage that is needed to go forward. And above all, right now, the ABA has come up with counselors. You can be able to speak to them about it and have courage throughout the process. Courage is not necessarily supposed to be at the start of the process. You gain it as you go along. You gain it as you see the perpetrator being brought to book. So what I will ask you, come to us, we'll have a chat. We will not pressure you. We'll have a chat. We'll tell you what the procedures are. We'll tell you what will happen when you raise, the fears of retaliation. But what I will tell you, a senior partner is not above the law. A senior partner is not above the law. And one step further, we are, as a gender committee, ensuring that once we get such a report, we go to our files and see whether this is a perpetual offender. So we might become your bystander. At the same time, ensure that confidentiality is upheld in regards to your report.
Just to follow up on that, is there a direct contact, or does one have to come straight to physically to LSK to report?
There is a direct contact. I think I saw my committee secretary, Vanessa, here. Vanessa Tabut at the secretariat. You can call her. She will be able to talk to you, send you a form on email. It is not a must you come to the Law Society. Come to the Law Society when you're ready, when you feel that you need to talk face-to-face, either to Vanessa as the custodian of the reports or to me. We will make time to come to the secretariat. But the form is on our LSK website. You can download it. You can fill it in. You can send it to us through gender reporting. That is R at genderreporting@lsk.or.ke, or get in touch with Vanessa Tabut at the secretariat. Her email address is, let me just check on the email. I think it's vanessa.tabut@nsk.or.ke. Get in touch with her. She will be able to guide you. It is not a must that you come physically to the secretariat. Our agenda desk has evolved with COVID-19. It's online. Thank you.
Lovely, lovely. As you've heard, you can simply reach Vanessa Tagut via email or approach the gender reporting desk via email. I believe Vanessa will type out the addresses in the chat box. And Senior Counsel John Chigiti is asking, is there anything for intersex persons? Is there anything for intersex persons? I will throw this out to my seniors, whoever will feel comfortable answering the question or is knowledgeable in the area. Perhaps Mr. Senior Buta Siganga.
Okay, let me attempt that. I think, and thank you, John Chigiti, Senior Counsel, for asking that. The people who get harassed at work, it's done irrespective of whether you're male, female, intersex, or any other identification. So I think the protection should be for everybody. And as I said, what we need to do is to come up with a coherent philosophy of how we're going to deal with issues. I saw in the chat somebody, Caroline Geshu, says we shouldn't sugarcoat, and I agree. Sexual harassment is something that we must deal with decisively, but to be able to do so, we need to come up with rules and regulations that really protect people. They protect, first of all, they properly define what harassment is, and then those who make the reports are protected from retaliation, are protected from lawsuits and criminal prosecutions and things. It has to come as a package, otherwise then you'll have people holding back, because the repercussions can be pretty serious. If you're a young person in a profession that you're going to be in for the next 30, 40 years, you don't want to be blacklisted in year one. So everybody should be protected. I think it's our collective responsibility to come up with rules, regulations, and protections that will ensure that this can happen.
Absolutely, absolutely. If there's any more questions, feel free to continue typing in the chat section. But at this juncture, I would like to ask our speakers to just say their closing remarks. What is your parting shot? If someone didn't get anything from this session, what would you let them know? What would you want them to know? Perhaps we could start with Ruby.
Thank you very much, Leonora. So pretty much my parting shot would be three-pronged. As a number of the other panelists have emphasized, is that the workplace is one of those places where we end up spending a significant part of our lives. So really, there's an obligation, first of all, on the individual level to try and make it safe and secure for everyone else, but also now to the leadership team also to do all that is required to ensure a safe and healthy environment for the team, because it's not only what is expected for individuals for us to feel safe and secure, but also it's a key ingredient towards ensuring that the teams are able to bring their best selves to work. That's the only way in which people are able to deliver the best work also. In addition to that, just the reminder that under Section 6 is that requirement that if you have employees more than 20, that sexual harassment policy that is required, but are also very emphasizing that of the LSK policy down from 2019. Doesn't matter how strong you are, then this policy is important. And let's not just put policies for the sake of complying with this. Let's put policies and implement them, do the training, as Senior Producer has said, and do that refresher courses to emphasize them and towards ensuring that we actually end up having a safe and healthy work environment for every person. Thank you very much.
Thank you, Ribin. Thank you, Ribin. Couldn't have said it any better. Miss Beth Michoma.
For me, I think I must emphasize every member of the law society should actually have a zero tolerance policy for sexual harassment. It does not matter whether you're a partner or an associate in a firm or a legal officer or a legal counsel in a government institution. And when you spot this evil, when you spot this vice, speak out for those who cannot speak out for themselves. Ensure that you raise awareness in your own little world through your social media pages. You might be able to help a soul or two come to terms with what has happened to them. Also, we should really invest in the mental and emotional well-being of the people who work with us. We need to go forward knowing that we have created a safe environment for everyone to be able to prosper and be productive at the workplace. And finally, I think I agree with a member who basically said sexual harassment should be taken with the seriousness it deserves in regards to disciplinary action. One instance I have had, and there was a bit of resistance, where basically I stated that a member of the profession who sexually harasses someone should be disbarred. It is something we need to talk about going forward. This vice should not be let to just slide by the wayside, because the people who are coming after us may actually suffer from our inactiveness. Thank you.
Absolutely. These are discussions we really need to have and ensure that our future generations are not given the impression that it is okay to continue with such behaviors. So those deterrents need to be put in place. I absolutely agree. Senior Counsel, would you like to say something?
Yes, just to emphasize the fact that lawyers hold a special place in the community. We have been mandated with the task of protecting the weaker people, speaking out for them, representing them, advising them. And because of that fiduciary relationship we have between us and our clients, we're expected to respect the law. We're expected to protect the clients from wrongdoing. We're supposed to ensure that we don't engage, in behavior that now will have our own conduct being scrutinized. So we need to avoid bringing disrespect upon the law, and just come up with. I think if you look at other professions, other industries, they've gone far ahead. If you look at doctors and psychologists and psychiatrists, they have very specific rules regarding this. The law has been left behind, and that's why the debate is, if a lawyer is supposed to protect, what happens if he breaches the law? Shouldn't he be treated differently and more severely? So I think it's something that we need to take in hand and say, we need to do something about this. I think for too long we've sat and passed on anecdotes and talked about this happened to that person. And I'm sure if you asked anybody in this meeting to tell you what they've experienced, what they've had, we could be here until tomorrow. But we've gotten to the point where we need to then move on and say, what are we going to do about this? Thank you.
Thank you so much, Senior. It's a critical point we've reached where we need to stop talking and start acting. So we take that as a challenge as the Law Society of Kenya, and we'll definitely start acting towards implementing some of these things and ensuring that higher deterrents are put for our fellow advocates in such scenarios, and just to discourage such behavior. But I thank you for everyone who attended this webinar. Thank you for participating and being so patient and involved in the process. Thank you to our speakers for making time and being so informative, sharing your knowledge with us. It has been a good session. For now, I would like to hand over to Ms. Ndinda Kinyili. She is the chair of the Nairobi Legal Awards Technical Committee and a member of the trust. So to close the session, welcome, Ms. Ndinda.
Yes. Good afternoon, everybody.
Good afternoon.
Yes, thank you all for attending today's session, which was clearly very informative. I would like to thank the Law Society of Kenya, the Nairobi branch, for hosting us today. I would like to thank our speakers for that engaging and clearly very informative presentation. I would also like to thank you, our audience today, for staying with us throughout the webinar. I would also like to appreciate our secretariat for being behind the scenes and making this possible today. I would also like to invite you to the Nairobi Legal Awards, which are scheduled for the 26th of November this year, so that you may come and celebrate legal excellence in our profession. Thank you all and do have a lovely afternoon.
Thank you very much. Have a lovely afternoon, everyone.